So, commissioners, this matter is submitted.
Thank you, and thank you everyone for testifying, and as well as the written submissions earlier provided by Ms. Laborde and by the department. Under Rule 10A, we must find that the city intentionally or inadvertently caused the requester to be late in filing the appeal. In my view, there's ample evidence of that. I believe that the city has not protected the rights of Ms. Laborde, and from the testimony tonight, it's clear that the city has not protected the rights of everyone who has been, who has spoken, and who feels strongly about this issue. We are not deciding the issue of the appropriateness of the matters within the letter itself. We are deciding whether Ms. Laborde and others have a voice in that process. And I believe that has been met. I believe in terms of the particulars of Rule 10A, the attorney for GEO stated this is not an extraordinary case. I do not read Rule 10A as requiring both an extraordinary case and the inadvertent blocking of the ability of the person to request an appeal. But even if it were part of the requirement, there's ample evidence, overwhelming evidence, that this is an extraordinary case. We've heard Compton talk about, we've heard references to Stonewall. Others have compared Compton's to the Woolworth's counter in Greensboro, North Carolina. It has been recognized as tremendously significant, so even if there's a separate requirement for extraordinariness, it is met here as well. In terms of what the city did or did not do, the city has granted a right for people to appeal a letter of determination, but it has not protected their carrying out that right. In the past, I've talked a number of times, and I've raised this with the department, about protecting the right of privacy. Our city protects the right of privacy in many of the land use determinations. But the holder of the right to privacy is not at the table when the city is making its determination. And in this case, we have people who, through Ms. Laborde, who has made the extra step, has paid for the request to be notified. And if you look at the BBN, it requires a level of experience and expertise in land use that I don't believe the city should expect the average resident of San Francisco to have. And it talks about applications under city review, capital R. And those are a certain set of determinations. But this is a review. This is the request for the letter of determination was reviewed by the department, but it wasn't a capital R. It was a little r, and people are supposed to know the difference. It talks about applications for a property, and this was a request about the property, and that's the difference between why it's in the BBN and why it is not. Now, I don't think it's reasonable for San Franciscans to know the difference between an application and a request, the legal difference, particularly when requesting the request for, you request a block book notice and you do it with an application form. So the terms are blurred. I don't for a second think that this is an intentional singling out of any party, any member of our community, but it is an area where this city, and again, it's not Mr. Teague, it's not the clerk, it's not the department, it is the city. It is city, it was this intentionally or inadvertently caused the requester to be late in filing the appeal. And just finally, before I recognize my colleague Commissioner Swig, who asked to be recognized, I also, in expressing my view that we should take jurisdiction, it does not necessarily set a precedent that every person has the right to have a late application. It is in this case, Ms. Laborde has taken the steps. What she felt and what a reasonable person would feel is the request to be notified about a property and paid for that right. The fact that there is a separate process and it is limited to neighborhood organizations, community organizations, I applaud the city for having that, but I believe it should be extended to all persons, all individuals. But that's for another day. That's for our discussions with the department, et cetera. On this particular case, I believe Ms. Laborde has met her burden, and I will be prepared at the end of this to move that we grant jurisdiction. Commissioner Swig.
Thank you. I agree and will not challenge anything that the President just said. I'm just going to amplify a few things. First of all, I stated earlier that I'm the one who looks at the law constantly. Even though I don't like the law, that's the law we're saddled with sometimes, or the regulation that we're saddled with, and we have to abide by the regulations, and the regulations are created by the people we elect in office. Look what we have in Washington, D.C. He rolls his eyes sarcastically, sadly, and tries not to break into tears. Put that in parentheses. Sorry. I'm really sad these days. So, that being said, so I'm a law-abiding citizen, and I respect the law and the regulations. And so the law and the regulations, as Mr. Teague said, say that, well, block book notices, we don't have to, the regulations state that we don't have to send letters of determination to people in good faith who register on block book notices. I recognize that. So if we were just going on that, then I would have to be in conflict with the President. But I'm not. What I feel here, and it was really clear, and thank you for the public testimony, really important, and that's why we have it, is it reminded me of watching the movie Casablanca when Louis says, let's round up the usual suspects. Well, this is the bureaucratic process. The usual suspects were rounded up. The notice or the letter of determination was circulated to certain community organizations, the typical ones, certain legislators, the typical ones, all the typical ones. Guess what, folks? This group of interested parties are not the typical ones. You have testified to that tonight. So where were the atypical parties? Where were the community organizations that are heavily focused on this as either a historic site, as an LGBTQ important site, as whatever, as your temple, whatever you want to think? There's lots of organizations that hold this site in sanctity. And that's what we heard tonight. These organizations are public organizations. They're registered as nonprofits. They're registered as interested parties. They weren't notified. Guess what? City failed it. City erred inadvertently. And so that's my spin on supporting the President's motion when it comes.
Vice President Epler.
Thank you. I agree with what my fellow commissioners have said and how they've couched this. Just a couple of small points. One, I do if you do have a neighborhood group, do get on the group notification list now. You know about it. Please do this so that you can actually get the notification and not have to fight through this process again. I do think about the standard that we have in order to find a jurisdiction request, and it does not refer strictly to what the code says in this circumstance. It's just whether the city inadvertently caused. In this circumstance, it's inadvertent. I believe that in my heart, but does the city inadvertently cause it? And, Look, I'm an attorney, not a land use attorney, but an attorney. I have been the president of a neighborhood association for 10 long and grueling years. And until tonight, when I had to actually dig into it, I did not know that I only got letters of determination by the grace of the planning department, not as part of the normal notification requirements, because I never looked at that before. And if they stopped going away, I wouldn't understand why that had happened either. And so this is very, very in the weeds, very confusing, very discretionary. And if you go through the process, as President Trezvina pointed out, of getting notifications on a parcel, it takes a lot of understanding, reading, and experience to understand what subset of those notifications you're actually signing up for in this circumstance. And I think that with that complexity, the city inadvertently caused this lack of being able to file a timely appeal, and it's right there on the corner of the case because it's right at the precipice of going either way. But it's the way that my fellow commissioners have presented it tonight.
Yeah, I just want to thank everybody who's come in this evening to express your views. And I, for one, did not know the history of Compton, so I'm appreciative of learning that. Also, as a former resident of New York City, anytime that we have something above them with Stonewall, that makes me happy. The advice that Vice President Epler just shared, just to frame it, and it looks like we're heading in a direction to grant the jurisdiction request. But that's for this question. Procedurally, that does not change planning's practices of BBNs versus registered group notifications. And so do please, anyone who's concerned and a member of a group, do inquire to get registered. It seems like there's representatives of groups here that may be eligible for that type of the registered group notification. Because as we heard from Mr. Teague, that review of what is officially included in something like a BBN notice is currently being discussed. I really hope that planning takes tonight's discussion into consideration in terms of what's included in a BBN. But we can't, as a body, guarantee what's in those BBN versus registered group notification buckets. And so you would be, I think, well served if you're interested in things like this to pursue that. I would say as an aside that from my perspective, an LOD should be included in a BBN notification. And I say that as someone who's been kind of skeptical of the BBN practice in the past for different reasons. But I think if we're going to do it, I think we should do it properly. Because the fact is that the LODs can be, a prior condition, practically speaking, for somebody being able to access funding for a project, for somebody to proceed confidently with prior planning for development. And I think if the BBN is partially intended to provide that notice to interested parties, we're learning, I've learned this evening, and with this case, with reviewing the materials, that it's limited to the very limited kind of permit and variance questions, as President Trezvina shared, that fall under that capital R review umbrella. But the fact is that parties often get that LOD as a prior condition to then file a permit confidently. And I think, folks who have expressed that interest in what happens at a property should get that advance notice that, before fundraising and everything else has taken place, if there's a reason under the law to appeal that LOD to kind of nip any type of project in the bud, so to speak, then I feel like someone who's expressed that interest, who is paid for BBN notice, should get a notice of something like an LOD. And it seems like, there's a long list. We heard 47 groups were notified with this particular one. It doesn't seem like too much to kind of comb through the BBN list as well. And I think in my mind, hearing, and I appreciate Mr. Teague's testimony with respect to explaining what's included in the BBNs, what's in the different, registered group bucket. It just doesn't stand to reason to me, learning of those different categories, which I do think are very in the weeds, and they're, in some ways probably only really relevant to very kind of focused land use practitioners in some ways. It just doesn't stand to reason to me that somebody getting a citywide kind of LOD notification in the sunset would have gotten this LOD, and then someone who's filed the BBN for this specific property doesn't get that same notice. That just seems odd to me. So with that, I'll support whatever motion our president wants to make on the matter.
Thank you, Commissioner Lopez. Just three very brief matters. One is, as we are going to be taking jurisdiction of this matter, want to assure all parties that any hearing we have will be full and fair, and we will consider all arguments that are relevant, and I want to make sure that what we are deciding tonight is the jurisdiction question. Second is, I know that Mr. Teague is extraordinarily conscientious and aware of input and receives input. And I did not hear any resistance to the notion of including the LODs within the BBN. So I just want to know that he's not required to give a position on it, but I didn't hear any resistance. And I do know that there are many people on the second floor of this building who follow these proceedings, and I think the message tonight from this side of the dais, as well as from members of the public and on Zoom, will be heard. And finally, I would just say how easy it is, because already on the BBN application, there is the listing of the things you want to be notified for, and then there's a box for other. I've typed in letter of determination, so it's not technologically difficult to accomplish this. So with that, I will move that to grant jurisdiction over this matter based upon the city's inadvertent causing of the requester to be late in filing the appeal.
Okay, on that motion, Commissioner Lopez.
Aye.
Vice President Epler.
Aye.
Commissioner Swig.
Aye.
So that motion carries 4-0. And Ms. Laborde, you need to file your appeal within 5 days. If you want more information, call us tomorrow about the process. Your brief isn't due at the beginning. It will be later. So just contact us tomorrow. Okay, thank you. That concludes this matter.
I'd like for us to take a 10-minute break.
Okay.
And return at 7:40.
Okay.
7:50.
For the other parties, thank you for your patience. We're taking a 10-minute break.